Welcome back to the deep dive. You know, usually when we crack open a case file on this show, we're talking about dirt.
Right. The actual ground.
Yeah, the bread and butter of urban development. You buy a plot of land, you want to build a tower, the neighbors complain about the shadow, and, well, eventually everyone ends up in a hearing room arguing about setbacks. It's very standard two-dimensional planning, length and width.
Exactly. The usual routine.
But today, we're throwing out the dirt entirely. We are looking at a case where the land in question doesn't actually exist yet. It is literally thin air.
It's fascinating. We're talking about air rights.
Yeah. So we are deconstructing the decision in Yulkarafat Acquisitions Corporation v. Toronto. This is a local planning appeal tribunal decision, or LPATR, that was issued on May 12, 2021. And if you are a planner, especially if you're currently staring at a stack of notes preparing for your professional exam.
Oh, this deep dive is tailored specifically for you.
It really is.
It's a goldmine for exam prep because it touches on, well, practically everything. You have massive infrastructure, you have the strategic procedural side of appealing non-decisions, and you have all the legal gymnastics required to build a city on top of active train tracks.
It is a classic unlocking land scenario. So the mission for this deep dive is pretty specific. We're going to dissect this decision to help you understand how the tribunal handles appeals based on neglect or refusal. And we're going to get into the really specific mechanics of developing over rail corridors.
Which is becoming a critical skill set, you know? In dense urban environments, we've basically run out of the easy sites.
We have. The easy dirt is gone. So let's set the stage here. We are in downtown Toronto. Specifically, we're looking at the railway lands between Bathurst Street and Blue Jays Way. And if you know the city, you know this spot. It's that massive open scar of tracks right near the Rogers Center.
Right. And in planning terms, it's currently a utility corridor. It is designated on Map 18 of the official plan. So it's industrial, it's noisy, and it effectively cuts the entire waterfront off from the rest of the city.
It's a huge physical barrier.
Okay.
And the vision here, which was proposed by the appellant CRFT Acquisitions Corporation and PITS Developments, Inc., it wasn't subtle at all. They didn't just want to build a building.
No. They wanted to construct a large-scale mixed-use development.
Right.
But the part that really sells it, the part that gets the public and the politicians excited, is the major park and open space component.
That is the key planning concept here, which is decking. The whole project involves merging air rights to build a platform directly over the railway corridor.
And the planning objective, which is explicitly stated in the source documents, is to reduce the barrier effect of the rail corridor.
Which is just a huge deal in urban design. I mean, rail lines are totally necessary for the economy, obviously, but they completely sever the urban fabric. They create these massive dead zones. So the idea of stitching the city back together with a major park is incredibly compelling.
And to show they weren't just, sketching this on a napkin in a coffee shop, the applicant brought in some serious heavyweights. The source material really highlights the involvement of architects who have received the gold medal from the Royal Architectural Institute of Canada.
And the American Institute of Architects too, right?
Yes, both.
I saw that.
Yeah.
They specifically mentioned Billietian and asymptote architecture, and the decision even references Asymptote's work on the Marina Hotel in Abu Dhabi.
Right, the one right at the Formula One circuit.
Exactly. So that sends a pretty clear message to the city and to the tribunal.
Yeah.
It says we aren't just building another condo, we're building a global landmark.
It establishes the scale and the seriousness of the application. But, and this is the reality check for you listening, you can have the best architects in the world, and you can have a really noble goal like a rail deck park, but you still have to get through the procedural grinder of the Planning Act.
Okay.
And this case is an absolute masterclass in how messy that grinder gets when you leave the ground level.
Okay, so let's get into that grinder. This is the real exam prep part. Section 2 of our outline, the procedural framework, the applicant filed 2 specific applications with the city. What were they?
First, they filed an official plan amendment, or an OPA. They wanted to amend the railway land's west and central secondary plans to actually allow for this mixed-use density.
Okay, that part is pretty standard. OPA, check. And the second one?
The second one is where it gets highly technical. They filed a consent application.
Let's pause there for a second.
Yeah.
Because usually when we talk about big developments on this show, we're talking about zoning bylaw amendments or site plan approvals.
Right.
Why a consent application? Isn't that usually for, like, severing a backyard lot to build a granny flat?
Usually, yes. But this is very specific to the air rights nature of the project. You see, the air above a rail corridor isn't just one big empty legal block. It might be owned by different entities, or it might have complex easements for the trains running below. To build a continuous deck, you essentially have to sever the air rights from the ground rights. You're separating the sky from the tracks, and then you have to merge those various air parcels into a brand new developable title.
So you're legally creating a completely new property that just floats 20 feet in the air.
Precisely. You are creating a stratified, fee simple estate. And doing that requires a consent under Section 53 of the Planning Act.
Okay, so they filed the OPA and the consent,
Okay.
and then nothing happened.
Right. The city didn't say no, they just didn't say anything fast enough.
Yeah.
This entire appeal was triggered by neglect or refusal to make a decision.
So if I'm writing an exam right now, and I need to cite the specific triggers for this appeal, what sections of the Planning Act am I writing down? Let's give them the exact numbers.
You are citing two specific subsections. First, subsection 22.7. That covers the appeal of the official plan amendment due to the city's failure to act within the statutory timeframe.
Okay, 22.7. Got it. And for the consent.
That one is subsection 53.14. This is the appeal due to the, quote, failure of the City of Toronto Committee of Adjustment to make a decision regarding the consent application.
I have to laugh a little at the image of the Committee of Adjustment handling this. I mean, this is the body that usually sits around arguing about whether a front porch is 6 inches too close to the sidewalk.
Exactly. Just imagine walking into that committee room with a multi-billion-dollar air rights merger involving CN Rail, international architects, and insanely complex structural engineering.
They wouldn't know what to do with it.
No, the Committee of Adjustment is simply not equipped to handle that level of complexity in a standard 20-minute hearing slot.
So inevitably, they don't decide. The clock just runs out.
And the applicant appeals under 53.14 to get it to the LPAT, which is now the OLT, where they can have a proper multi-week hearing with actual expert witnesses.
And looking at the timeline and the source, it was definitely a multi-week affair. The decision notes proceedings happened intermittently from November 2020 all the way to March 2021.
Which signals the sheer volume of evidence. This wasn't a quick legal argument. And when you look at the cast of characters involved, you really see why.
Let's do a roll call of the players then. Who is actually fighting this battle?
For the applicant, CRFT, you have a powerhouse legal team. Ira Kagan, Christy Jennings, Barnett Kussner, and Denise Baker. These are names you see on the biggest files in the province.
Navigators.
Very much so. And on the planning side, they had Mr. Ian Graham presenting evidence.
And what about the city?
The city was represented by Brendan O'Callaghan and Joanna Weiss. And interestingly, the sources mention the direct involvement of Mr. Greg Lintern, who was the city's chief planner at the time.
But there were other parties too, right? Because obviously you can't build over a train without the train company getting heavily involved.
Correct. You had Canadian National Railway, CN, and the Toronto Terminals Railway, or TTR, listed as parties.
Okay.
And that immediately tells a planner that this isn't just a zoning dispute, it is a massive engineering and safety puzzle.
Right, because the tribunal has to weigh the planning merits against the operational safety of a national rail corridor.
Exactly. So let's get into the tribunal's analysis. We have the players, we have the site, we have the legal triggers. What were the actual friction points? Because looking at the decision, it seems like the strategy CRT used was a little unconventional.
You're talking about the OPA without zoning thing.
Yes. This is a critical issue for you to study. CFT submitted an official plan amendment without simultaneously seeking a zoning bylaw amendment.
Which feels backward, or at least incomplete. Because usually developers just throw the kitchen sink at the city. They file the OPA, the zoning, the site plan all at once. Why would they hold back the zoning part?
It comes down to risk management and cost. Just think about what is required for a zoning bylaw amendment on a site like this. To zone for a specific building envelope over an active railway, you need incredibly precise engineering. You need to know exactly where the structural columns are going to land between the train tracks down to the inch. You need wind studies, shadow studies, crash wall designs for the trains.
That sounds extremely expensive.
We're talking millions of dollars in consulting fees up front. So if you aren't even sure the city supports the basic idea of the development, like the high-level policy in the official plan, why would you spend that money?
I see. So Crafty's strategy was to get the OPA approved first, establish the principle of the development, get the tribunal to say, yes, we can build mixed use here. And then once that is legally locked in, do all the heavy lifting and spending on the precise zoning details.
Exactly. It's a way of de-risking a massive project. However, the tribunal's commentary on this is really fascinating. The decision notes that while this may not be the norm, the tribunal does entertain it.
That's interesting.
Yeah, there is no absolute requirement in the Planning Act that forces you to file them together.
And that is a key exam point right there for you listening.
Yeah.
Just because it is standard municipal practice to bundle applications doesn't mean it's statutory law. You can legally split them.
You can. But, and it is a really big, but it creates massive friction with the municipality. Which brings us perfectly to the second key issue, which is parkland dedication.
Right. The major park was the big carrot for this whole project. The developer's basically saying, let us build these towers and we will give you a beautiful park over the tracks.
Precisely. But the city looked at this OPA-only strategy and said, hold on a second. If we approve the official plan amendment right now without the detailed zoning, we lose all our leverage.
How so? How do they lose leverage?
Well, the source text explains that the city felt it had no alternative but to seek a dedication of parkland from each applicant as the zoning bylaw applications are filed for those smaller individual sections.
Okay, unpack that a little bit for me.
Imagine you are trying to assemble a massive, cohesive central park. But because the developer hasn't submitted a comprehensive site-wide zoning plan yet, you have to approve the park in little postage stamp pieces, building by building, maybe over 10 or 15 years.
Oh, I see. It just becomes a patchwork.
Exactly. The city argued that by bifurcating the process, doing the OPA now and the zoning much later, the developer was making it virtually impossible to secure the major park as a single, functional, cohesive entity. It really highlights the difficulty of securing public benefits when you don't have the detailed zoning locked down all at once.
So the city is basically saying, you're promising us this incredible park, but the legal mechanics you're using mean we might just end up with a bunch of disconnected grass patches.
That is exactly the tension. The developer absolutely wants flexibility to phase the project, and the city absolutely wants certainty that they get the park they were promised. And the tribunal has to sit there and referee that match.
It really demonstrates the interplay between financial strategy and planning policy. Now, I want to circle back to the third key issue from the source, which is the technical mechanics of the air rights themselves. We touched on the consent application earlier, but I want to make sure you truly understand the serve and merge concept.
This is pure technical planning. Subsection 53 of the Planning Act. Like we said, it's usually used for splitting land up. Here, it is being used to stitch land together.
Or rather, stitch air together.
Right. To build a deck, you need a single, clean property title to build upon. But the air over the rail corridor is highly fragmented among different owners, so the consent application asks for legal permission to sever the air rights from the ground rights of various parcels and merge them into one new superparcel.
It sounds like legal quilting.
That is a great analogy. You are literally taking scraps of air rights and quilting them into a developable blanket. And the key takeaway for the exam here is that this process creates a stratified property. It's a property that only exists within very specific vertical coordinates.
It starts at 20 feet up and ends at 500 feet up.
Exactly. And the reason this whole thing ends up at the tribunal in the first place is purely because of that complexity.
Right. It's a failure to decide appeal because the standard municipal system just grinds to a complete halt when faced with something this non-standard.
Yes. The city planners are used to ground-level zoning, not creating land out of thin air.
So let's try to synthesize all of this. We've covered a lot of ground today. Or air, I guess. If I'm a student reviewing this deep dive from my notes, what are the 3 big bullet points I need to take away from CIFTV Toronto?
Okay, pen and paper ready. Here is the summary. Number 1 is the procedural triggers. You really need to know that complex files often bypass City Council entirely through neglect or refusal appeals. Specifically, you want to cite subsection 22.7 for the official plan amendment and subsection 53.14 for the consent application.
Got it. 22.7 and 53.14.
Number 2 is the strategic split. You need to understand that an applicant can appeal an OPA without a concurrent zoning bylaw amendment. It is a totally valid strategy for de-risking high-complexity, high-cost sites. But you must be able to explain the downside on your exam. It deeply complicates the securing of comprehensive public benefits, specifically like parkland dedication.
It's the classic trade-off of developer risk versus municipal certainty.
Exactly. And finally, number 3 is the mechanics of air rights. Don't just think of decking as a cool engineering feat. It is a legal feat first. It requires consent applications to sever and merge air parcels. If you can explain to your examiner that the legal creation of the land is just as hard as the physical construction, you will demonstrate a superior understanding of the material.
And I would add just one more layer of context to that, which is the why. All of this procedural headache, all these lawyers and hearings, it's all in service of a specific planning objective, which is reducing the barrier effect of utility corridors.
That's crucial. We don't just do this for fun or because we like legal puzzles. We do it to unlock land in dense urban centers that desperately need it.
It really puts the planning in the Planning Act. We're trying to engineer a better, more connected city using these legal tools.
Even if those tools, like the consent application, were originally designed for simple farm severances in the 19th century.
It's like using a hammer to perform surgery.
Basically, yes.
Well, before we wrap up today, I want to leave you with a final thought to mull over. We spent this whole time talking about the process, the lawyers, the tribunal hearings, the failure to decide mechanisms.
It is a very intensive process.
It really is. But as our cities get denser and denser, this kind of development, building over train tracks, building over highways, it's going to become the norm, not the exception. We are simply running out of simple dirt.
That is an absolute fact. The easy sites are gone.
So here's the question for you to explore. If the only land left in our major cities is thin air, does the current Planning Act actually provide the right tools to manage it? Or are we just destined for a system where every single creative project requires a 6-month tribunal hearing because the standard municipal tools just can't cope with the complexity?
That is the multi-billion-dollar question right there. I mean, if the system relies on failure to decide appeals just to get anything innovative done, maybe the system itself needs a major update.
Are we actually democratizing city building? Or are we just creating a system where only the players with the deepest pockets and the biggest legal teams can even afford to unlock the land?
It's definitely something you should think about critically as you study these sections for the exam.
Well, on that cheerful note, thank you for walking us through the CRFT decision. It is an absolute beast of a file,
Yeah.
but I feel like we've tamed it.
My pleasure. It is a really fascinating case study.
And to you listening, good luck with the exam preparation. You have the sections, you have the arguments, you understand the mechanics. You've got this. We'll see you in the next deep dive.